evening. I'll begin.
Uh, no, let me introduce you for sake of the
Okay.
news. Welcome everyone to NNBF Coffee Chats. It's a Christian discussion forum, but we also have programs and talks for the greater society. And today is one such talk on succession and redevelopment. Our speakers today are Advocate Sharon Rodrigues and Advocate Chandravali Nair. Just a quick introduction about them before we invite them to lead us in this today's session. Advocate Sharon completed her master's in social work in 2004 and has been a practicing lawyer since 2011 under her late father, Advocate Leo Cardos, and advocate. I think her formal practice started in the year 2014, and Advocate Chandravali started her formal practice as a lawyer since 2015. Both of them work together as a team. They handle civil and criminal litigations in major Mumbai courts, including High Court, Family Court, and Magistrate courts. Besides, we also provide legal consultancy and all. Besides, they also provide legal consultancy and all documentation services, including compliance for cooperative housing societies or retainership. Okay, so that's about both our speakers today. What we'll be doing is first, both of our speakers will be speaking for a length of time, and then we will have a part two of today's session, wherein we will have Q&A. Okay, so over to Advocate Sharon and Advocate Chandravali. Thank you.
Okay. A very good evening to all our members over here. The topic that was given when Abhijit sir told me, I said it's a very vast topic. And I discussed with Advocate Chandravali. She said that Sharon will touch on the highlights of the topic. And of course, succession and redevelopment itself is each session, each topic is a 2 hour topic. But talking about succession, okay, when we come specifically to India, okay, so, it is governed by the Indian Succession Act of 1925. And in succession, we have various kind of successions. We have testamentary successions and in estate succession. Okay, when we say testamentary succession is where there is a proper will in place. There is a will produced by made by a person, and that on basis of that will we make a testamentary petition. In estate succession is where there is no will. The person has unfortunately many a time because of sudden death. Okay, then that is called in estate succession. These are the two types of succession. Now, what is a succession certificate? Okay, and of course, even in the previous what you saw that testamentary successions, most of them happen in High Court. Okay, when it comes to governed by Indian, all the properties governed, and domicile plays a very important factor to where you can apply your succession certificate. So, if your property is based, the person whose property who has passed away, the deceased, his domicile is very important to determine where he will ask for the succession. So we have that two successions, as we said, the testamentary petition and also the in estate. Now, what is a succession certificate? Okay, it's a legal document which is a court issued document, and most of nowadays, if you see, most of companies or certain departments of the government, they ask for the succession certificate if they want to endorse any right of the legal descendant. Okay, it's a proof of a legal heir that you are a heir of a person. Okay, and you have the rights as Chada ma'am has drafted over here, like bank balances, shares, insurance. It's got more to do with immovable asset of the deceased person. Okay, so here as it is mentioned, it enables the legal heirs to claim, transfer, or manage, okay, and provides protection to banks and the banks. So it's like an you indemnify when it comes from the court. Okay, the company or the bank or the government authority from where you're claiming the succession certificate gets assurance that whatever is given to you is given from a legal authority, because there is a procedure. Ma'am will explain, of course, that procedure. It's a legal procedure through a lot of NOCs and all different documents which are presented in front of the court, and based on that you get the succession certificate. So it keeps the core, the any department indemnified from any kind of, any fraud happening. Okay, Chanda ma'am, you can add to it. Okay, court will issue a succession certificate based on supporting documents, okay, subject to verification. So every document which is submitted in the court of law, okay, is subject to verification by the department. Advocate Chandra ma'am, you want to add to this slide? Okay, fine. I'll continue then. Okay. So purpose of succession certificate, it allows heirs to claim debt, securities and other movable financial, this thing is one. Okay.
Now,
Yeah,
should I
Chandra.
continue?
Yeah,
Huh?
continue, continue.
So it is basically succession certificate is for claiming right on movable assets of the deceased person. And
Hmm.
succession certificate is when you claim the movable assets, it is definitely a company or an employer of the deceased person who will ask for it. It is the person who wants the claimant, what he is claiming, from whom he is claiming. That is what is important. Sometimes it is a job that a claimant is wanting to have. A wife wants to claim the job of her deceased husband. So how does she go about it? Then supposing the husband was employed with the railways or some government department. So on compassionate grounds, the wife is entitled to a job if she doesn't have any major children. If her children are minor, then the family should not suffer. So the railways or the government department asks for a succession certificate. So then she has to go to the court and then say that I am the only successor who is entitled to take up the job because my kids are minors. Because even in case of succession certificate, the NOC is needed from the other successors. Now there is a difference between legal heirs and successors. Our audience also should know about this. Legal heirs, there may be more legal heirs. Movable assets movable assets generally it is presumed that the successors are close family members. So obviously a succession certificate is applied for by close family members. It is a wife, it is a children, it is a mother, or any close relative or a close family member. Because if it is a job, it is a bank account, then it is only the family member who will have an access. So mostly it is the self-earned movable assets which are uh, claimed through the succession certificate. That is a clarification here. Sharon ma'am, would you like to go ahead with this? Movable assets. I have made it very clear. Now, in case of some companies, if the deceased person has claims, he has some debts to pay, he has a bank loan, then some securities are there, he has some demat accounts, then the company may insist that you can get a succession certificate and the deceased person's succession can take over. He can repay the loan or a housing loan. If the husband passes away, the wife can pay out the housing loan. So she can get a succession certificate, and then if she is not a party to the loan agreement, then this is what happens. So it is a very specific requirement which is asked for by any institution or any person whom the successor is approaching. So this is one clarification I would like to add. Then this is generally to prevent disputes within the family members. So it is close family members who will go for a succession certificate. And it has a very limited utility. Anything streamlining asset transfer. It provides the legal basis for transfer and administration of deceased assets. Here we are talking about the movable assets specifically, not the immovable property. Because if it is immovable property, we have a different process for that. Protection for institutions. Again, as Sharon ma'am added, it is an indemnity to the company or an institution or a bank, whoever it is. That through it has been granted by the court, so we have given it to the successor. Can we go to the next slide? Next
Yeah.
slide, please.
Yeah,
Hmm.
the next slide. I'll go on to
Now,
the next slide.
this is also succession is through the legal heir certificate also. There is something like a legal heir certificate also. Now, who is the legal heir of the person? Supposing if I give you some examples there, it will make it very clear. So, if the father has, say, a pension account, and the children want to access the pension account, so the company who are or employer will ask for a legal heir certificate. If you are the so and so legal heir should, and there will be a specific agreement terms that my pension should go equally to all my children. So all the three, this is a joint sort of a legal heir certificate is a jointly applied for by the successors, family, close family members, children, wife and two children, and mother. So the proceeds can be equally divided amongst the successors. They are also legal heirs. Legal heirs and successors, there is a slight difference between. Legal heirs may be more. They may not be necessarily a family member. But if you don't have a close relative, then it is the legal heir who inherits your movable assets also. This is one clarification. Then succession certificate issued by a district or a civil court. A local court, district court can issue a succession certificate. Now, whereas a legal heir certificate is typically issued by a taluk, tahsildar office or a collector office. This is a very limited scope of a legal heir certificate. Now, scope. The
Yeah.
succession certificate is primarily for claiming movable assets. Again, we are talking about the same thing. While legal heir certificate confirms a relationship of legal heirs to the deceased. So we have clarified here, often used for other government-related purposes. Now, legal process for obtaining a succession certificate involves a formal legal process. That means you need a lawyer, then you have to file an application or a petition with all the relevant documents to before the court, and on merits the court grants the certificate. A legal heir certificate involves an inquiry by the revenue official. The collector will inquire. They will ask for certain documents. You have to supply those documents. The collector office or whoever, the revenue department, they will ask the detail and they will verify that. And after verifying, they will issue a legal heir certificate. Now, how to obtain a succession certificate? Consult a lawyer, advisable to seek legal assistance. Even the succession certificate also, some cost is involved, because depending upon the value of the asset, the court will charge a court fees. Because generally it is issued by the court, so the court charges a court fees. Then file an application. You must submit a petition to the district or civil court of the deceased jurisdiction. Provide the required documents, obtain an affidavit. All this is all. Get an NOC from the other successors. Supposing if the mother is applying, the children should give a NOC if they are major. If they are minor children, of course, then the mother has to give an affidavit saying that my children are minor and they cannot file an affidavit or they cannot give an NOC. So pay the court fees depending upon the value of the asset. Supposing if you have a 1 lakh worth of bank assets, then the court will charge some 7%, 7.5%, whatever it is. That is the court fee which is charged. Then court verification. Court will verify the applicant's claims and ensure fair distribution of assets. If the successor is more than one, then it is the court which will decide. Because in this case, you have to remember, when somebody is asking for a succession certificate, there is no will in place. The court will distribute it equally. If the wife and two children are claiming, each will get one third share of 1 lakh of rupees. That is how it is. Can we go to the next slide?
Yeah. Yeah.
What are the important considerations? In case of succession certificate, no will is required, or we presume that there is no will. That is why you
Mhm.
are the authority asked for a succession certificate. So, then immovable property. For immovable property, that is an entirely different process. It is called letter of administration. Then there is no time limit. There is no time limit for applying for a succession certificate. But in case of letter of administration, there is a time limit of 3 years. Within 3 years, you have to approach the court and get it. Now, the succession certificate, in case of succession certificate, it depends on the successors when they want to access the account. The moment they give the intimation to the bank or any company, then it is the time when they ask for the document. That is, so there is generally for a succession certificate, there is no time limit. So, Sharon ma'am, is that okay? Have I
Yeah.
covered everything? We have the
Yes, yes,
broader
yes.
aspects because we were asked to focus on succession certificate. But in
Hmm.
succession, in the case of succession, there are three things. Legal heir certificate is there, succession certificate is there, and letter of administration is there.
Hmm.
Now, letter of administration is entirely for a immovable property, like a flat or a land or a house or whatever it is, whether it is ancestral or it is self-acquired. Succession is normally for self-acquired property. So that is one thing. And letter of administration and succession, letter of administration has a wider scope and
Hmm.
can cover. It is sort of a blanket succession for all properties, movable, immovable, any kind of property. So that is a different process altogether. Now, in case of after beyond Thane, almost all the letter of administration of immovable property goes to the High Court. But in case of succession certificate, it depends on if the up to 1 crore, it will be some district court, civil court. But beyond 1 crore, it will be the Bombay High Court. That is the jurisdiction. If the value of your property, movable asset, is more than 1 crore, it will go to the High Court. If it is less than 1 crore, any civil court. So I think we have covered this very briefly. Sharon,
And
ma'am,
also,
would
I
you
would
like
like to add that, in this kind of matters, uh, it's always good to take an advice of a lawyer. Now, I have many people, Chandra ma'am also may be sharing the same experience. I have many people who come and say, that they have made their own will and they are prepared their will. But when we go and see, when we review their will, when they come to us and all, it is very, very ambiguous. The wills are not proper. For succession, their wills are many times not proper. So it's very, very important, taking a consultation of a lawyer, a legal advisor is very, very important. Even for a succession certificate, as ma'am said, movable property, it's important that if the authority is asking that this succession certificate, so suppose if you have made it for a particular bank or a particular department, that succession certificate, if you're using, you can also use it for another department. It is applicable to another department. So it's important when certain documents are requested by the court, I think we should process it. Okay, otherwise it becomes a very and in any kind of these kind of successions, no, we have to have a very, very, very clear document in place to show who will take over our property or what will happen to our property in case if anything happens to us. That clarity during your lifetime should be made. So that I would strongly recommend, because our experience of ma'am and mine is like, when we see certain documents and all, we look at how it becomes more long drawn. A succession, if it is not properly drafted or, the will is not proper, your process of obtaining these kind of documents become a little longer than as expected. So that's what I would like to add. Yeah. So that's Chanda ma'am, I would like to add. I added to that. So ma'am, I think we have covered, as ma'am said, very broadly. But of course, you can always raise your questions with specific
yeah,
specifications of any issue.
yes,
Okay.
for sure.
So should we go to the next topic, Abhijit Pastor? Abhijit sir?
Yeah, sure, sure, sure.
Yeah. Okay. Okay. Now redevelopment. Okay. This is very, very important. Redevelopment gives a new identity, old, properly maintained, poorly maintained, and dilapidated residential buildings. Okay, cooperating housing society. Okay, when you say redevelopment, when we say a cooperating housing society, building with pagdis and tenancies and leave licensed tenancies. Now, when we say redevelopment, these properties normally go okay under redevelopment. Now, when we say Pagdi system, I'm sure you all must be understanding Pagdi system where we pay and the landlord is there and we have a tenant who pays a certain amount to the landlord. Okay, so if the tenancy is for a long period of time, then what happens is, as we have mentioned, the negotiation happens with the landlord first. Okay, mostly the negotiation happens with the landlord, and there is a fair deal which is arrived at in consultation with the landlord, and 51% of the members have to agree to this redevelopment. Okay, so there is a procedure which happens. Okay, then we have SRA cluster development plans, a government sponsored welfare schemes. Okay, this mostly SRA is a slum rehabilitation scheme,
Redevelopment. Re-
okay. So
Redevelopment. Yeah,
yeah, so which
got it.
happens with mostly with slum areas, okay, and there are specifications as to what are the documents required and what are the legalities to show that okay you are a member of this. If you must be knowing that in redevelopment schemes, there are the government comes with survey. They have various surveys, voting cards. So these become very important documents when it is a slum rehabilitation. Whereas in Pagdi system, when you say the tenant and the landlord, the tenant and the landlord relationship should always be maintained. There should be no break in that relationship. So what determines the relationship is one is paying the rent, regularly paying the rent. The landlord you pay the landlord continuously without any break, so that creates the tenancy and landlord relationship. So if you want to claim your right, or you want to you want to be a part of the redevelopment, which is a Pagdi system, that relationship has to be maintained throughout. Okay, and SRA, as we have mentioned, you have to have relevant documents in place to show that you are an inhabitant of that place. Okay, and cooperating housing society redevelopment can be done in two ways: self redevelopment or partnering with a developer. Okay, so self redevelopment is where the society gets into negotiations or gets various builders to come and give them various proposals to say, come on, now this building, you do a structural audit and you say that the building is quite old enough and now we need to redevelop it. Okay. So then they come into a negotiation with the society, and there is a certain percentage of people who have to agree to this redevelopment. Partnering with the development. That, Chandra ma'am, if you can add to this point.
Now here also in cooperative, in case of cooperative housing society, buildings with pagdi tenancies and lease tenancies. Here I would like to differentiate. Most of the buildings earlier, say some 50 years back, the landlord used to just give his house on to any tenant, and nominal rent is charged like 30 rupees, 50 rupees per month, but no deposit, nothing like that. And then those are lease tenancies where there is no agreement, but there is the tenant is residing in that place for quite a number of years, 30 years, 40 years, 50 years. Now with 50 years, 50 rupees rent over the period of time, how much will the rent increase? 50 rupees, 60 rupees, 70 rupees, it will become 100 rupees, 200 rupees. Now it becomes difficult for the landlord to maintain the building. So in such cases, such very old buildings are also taken up for redevelopment. In case of Pagdi tenancies also, it is a similar situation. In case of Pagdi tenancy, the tenant is a 50% owner. The landlord is there, but the tenant is also there. Both, it's a partner ownership partnership, like sort of. The tenant is also an owner. He can sell the property. In case of lease tenancies, the tenant cannot sell his tenement. In case of a cooperative housing society as well, there also the tenant, he is also called a tenant only because he is the tenant of the cooperative housing society, because he is the owner of the only flat, but otherwise he is a tenant of the society, cooperative housing society. All the rights of the tenant are vested in a society. So you have a common, you pay the maintenance to the society, you have a common water connection, things like that. So for everything, you have to approach the society. If you want to do some kind of a renovation, you have to take the permission of the society. If you want to sell your flat, you have to go back to the society. You want to lease, you have to give your flat on a tenant to some other tenant on a leave and license basis, you have to take the consent of the society. So the society is your landlord, sort of. That is what is the difference between a cooperative housing society, pagdi tenancy, and a lease tenancy. In case of SRA, what they do is, this is a government authority. It is government schemes. Certain area, there are so many acres of land is there, and the government comes up with a scheme. So the government, what they do is, through the scheme, the SRA enters into a contract with the developer, and the developer will enter into contract with all the people who are residing in on that land. These are small tenements which are situated. They are either slums, or they are sort of, what, tax pauti ghar, what we call it. Slums, they don't pay any taxes, but otherwise there are homes, tenements where they give taxes, property tax, like the government, the municipality gives a tax pauti to them. So that way the SRA takes up such lands also for development. Now these are low housing cost housing project, like you have SRA and MADA projects come under this category. Now can we go to the next slide?
Yeah.
We will broadly deal with the cooperative housing society stages. Now, offer letter to the society. Supposing the buildings are seen about 25 years, 30 years, what happens is, normally in any of the buildings, not all the tenants are the real owners of the flats. Some of them are licensees. Some of them have just invested money. They're not staying there. Or some of them just limited interest. They are staying elsewhere, and they just bought this flat as an investment, something like that. So in such case, what happens is, after 25 years, 30 years, the society becomes quite old. Maintenance becomes an issue. Most of the societies are not properly maintained. That is why after 25 years, 30 years, they develop some structural issues, and then the redevelopment is taken up by the society. The society thinks of redevelopment. So the developers will come and give an offer to the society to develop the society. Then what are the terms and conditions? They also discuss the terms, and there are a series of meetings held with the society members. Here the redevelopment committee, sort of 3 to 4 members will be a part of that redevelopment committee, and then they will discuss the terms and conditions with the society. There is something called a corpus money, shifting charges, alternative accommodation to be provided to all the tenants, the area, present area, and the future area which the developer is going to grant. And now, what is the title of the developer? How does he acquire? So it is the society which gives the power of attorney to the developer. After that, finalizing the plan with the society. If they have any plans for redevelopment, the developer will give you certain plans, plan A, plan B, plan C, and he hold a series of negotiations with all the tenants, and come to an agreement, common agreement. Majority will agree on certain plan A, plan B, plan C, whatever, and depending upon that, the society will get a plan approved by members, and is submitted to the MCGM. This is municipal corporation, this is civic authority. Okay. Now the agreement with the society. How does the developer get into the agreement with the society? It is through the development agreement. There is something called a development agreement with the society, to be executed subject to approval of both the parties, developer and the society. And the tenant, of course, if the society means what? Society may be a legal person, but it is a sort of a body corporate. That means 20 members, 30 members, all the flat owners. Let us take it is the majority. 51% of the members of the society agree, and they come into a development agreement is drafted. So a suitable development agreement is drafted with the help of the society in consultation with the society lawyer and the developer's solicitor, depending upon the, supposing it is a three-storied building, there are about, let us take, there are 20 flats. Now he will give you a plan that I want to have 50 flats, 40 flats, whatever it is. So you are accommodated in the new building. So there is a, this is a proposal for giving a new identity to your old building. So that
Mm.
will, even if you, in case of an old building, if you undertake repairs also, that may have a limited utility. You know, after 3 years, again you may have to go for repairs. So generally, people they go for this redevelopment plan, which is a negotiable, and if there is a win-win situation between the members and the society and the developer, then they go for a redevelopment proposal. Then sanctions from MCGM favoring the society. All the layout plans, which are, these are all technical things which the developer does. Most of the things are done by the developer. Now, what you have to think of is the title of the developer, the title of the society, and the title of the owner, tenant. I mean the tenant. If the title of the tenant is in place, supposing the tenant himself is the owner of the society, or he is owning the flat with his wife, whatever it is, joint ownership, single ownership, whatever. So that is your title. Ownership of the society is whether the society is registered, and the title of the society is whether the land is conveyed to the society. Now, if the land is conveyed to the society, then it is again an add-on benefit to the members also.
Mm.
So that makes a difference in the corpus money which the tenant gets. So these are some of the basic things our listeners should know. Next, let us go to the next slide. Sharon ma'am, would you like to add something
Yeah.
in this? Hmm.
No, no, I think that's quite, yeah, you
Hmm.
can carry on, Advocate ma'am.
Hmm. Now, obtaining the IOD, intimation of disapproval. Now, IOD is a preliminary approval from the local municipal authority in India, acting as a conditional green light for a project to proceed after reviewing the development plans. So, these development plans are made by the society and the developer, basically the developer, along with the in consultation with the society. So they may not consult each and every member. A formal approval from 51%, majority approval, that's all. Then shifting of member, then comes shifting of members to a new premises. So, and generally, now when the redevelopment agreement is made, what we call is PAA, that is permanent alternative accommodation agreement. This is signed by the developer. So that is, if it is signed by the developer with each individual flat owner. So all of you, somebody, depending upon the area. So you are giving me 500 square feet. My neighbor will give him 600 square feet because he has a bigger flat. Somebody else will give him 1000 square feet because he owns two flats, that way. So that is how that PAA is made. So development agreement, and also their conditions of the development agreement also. Now you can vet these agreements. Society definitely does it, but then in case individual flat owners they want to vet, by vetting I mean VET I'm talking about. That is, if you want any your lawyer to scrutinize these agreements, uh, we can also provide help you with scrutinizing, like this, like what kind of, how much time it will take to redevelop the building, what is the kind. Now normally earlier what the developers used to do was they used to give alternative accommodation and they used to pay the rent themselves. But it is not, nowadays it is a different thing. They may not complete the building in the scheduled time. So what they do is they ask you to hunt for an accommodation, and then you get an accommodation. He will give you a lump sum amount as a rent to stay. towards the rent, and that rent reimbursement is done. So as long as the building is completed, he will continue to give you this rent. So now what is important is, earlier what used to happen is people used to be accommodated closely, but now what happens, somebody will get an accommodation in Thane, somebody will get in say Ville Parla, somebody will get in Santa Cruz. They are scattered. Earlier, all the members, tenants of the same society, now they are all scattered. They are scattered in different places. So it becomes difficult. So it is always important that all the tenants, they are in touch with each other, and you closely monitor what the developer is doing, how your redevelopment program is happening. So that is one. Then obtaining a demolition of the building. So unless all the members agree, and unless the PAA is signed by all the members, and the unless the all the members are transferred to the transit accommodation, the building cannot be demolished. Even one person says, "No, I am not ready to vacate the flat," he cannot demolish the building. So it is very much compulsory that the developer enters into an agreement with each of the society member, and then only the demolition of the building happens. Then obtaining CC. This is IOD approval. This is all technical. Then construction of new building takes place subject to approved plans and as per terms of PAA. Can we go to the next slide?
Yeah.
Next slide, please.
Next slide,
Yes. Then
Chandra.
obtaining OC. OC is the
Okay.
occupation certificate. It is the last step and enables the developer to allot the occupation uh, to old and new members. Now, as I told you, you are only 20 members in the society. But in the new building, it may have additional stories, and it may have some 40 members, 50 members, whatever. Or he may acquire the land, adjacent land also, and then he may construct two wings. So earlier only 20 members were there. Now it will be 40, 60, 80, whatever, depending upon the land he has acquired. Now, shifting of hold member, developer can lawfully allow possession of flats to be taken over by the owners. So what happens? He gives you an allotment letter. After completion of the building, he will give you an allotment letter. Depending on based on the allotment letter, you can occupy that flat. Then thereafter, after redevelopment, the new society is formed. Depending upon the occupancy, old society loses its identity. Usually, P triple A itself is the title document. Usually, if this is a registered document, this itself proves as a title document. And if it is not registered, then after getting the new accommodation, you will have to yourself get it registered. Now, one formation of the society, that all happens at a later stage. That unless he sells all the flats. Now, your flats are not saleable, not for sale, because you have already acquired you in lieu of your old accommodation. But the new flat owners who come, and all, unless the entire building is totally occupied, he will not move out of the place, and he will not form the society. So till then it will happen. But once you are moved to the new building, your rent and everything stops. So dispute resolution. We go to dispute resolution. RERA to adjudicate upon claims and complaints of members. RERA is Real Estate um, Redevelopment Authority. So in this case, RERA is a quasi-judicial forum. It's not a court, but then the procedures are like a court only. Now RERA Act, it safeguards the interests of these flat owners. Supposing you are moved to a transit accommodation, and if the developer says that after for 3 years I'm going to give you the rent, within 3 years I will complete the flat, your new building, and you will be accommodated in the new building. But he fails to do so. Then you can, if there are any disputes, any complaints against the developer, you can go to the RERA and file your complaint. That is any violation of the PAAA, that is this agreement. Any violation happens, you can approach the RERA, and then RERA will adjudicate upon these complaints of members.
Mm.
So this is one.
Also, I would like to
I
add
think,
to what ma'am said.
yes.
The RERA, what ma'am
Hmm.
said, it is they have their website, and it is mandatory for all
Hmm.
builders and developers to be registered in this. So if you have their license number, and you go to this website, you type their license number, you get all the details of how many projects are in hand with them, and whether it is successful or there are any cases against them. This website gives you all the details. So with
Hmm.
if you just type their license number on RERA, that is one thing. Second thing is, as ma'am mentioned, that occupation certificate. Now, this occupation certificate is a very, very crucial document. Not only you can go to RERA if it is not given, but you can also approach the consumer forum. Builders, developers who do not provide OC, occupation certificate, to the resident, the resident can drag the developer or the builder to the consumer forum. If you read up, I don't know whether you have seen, there are many cases where the developer has been booked under for not giving OC under the consumer forum of Consumer Protection Act. Okay,
Hmm.
yeah, that's what I
Now,
would like to.
occupation certificate, what happens is it is not why the builder does not give you the OC. It is because he has made some violations of the plan.
Mm.
Some alterations in the plan. So it is the civic authority that doesn't give him the OC. So if the civic authority doesn't give the OC, he cannot give you the OC. Supposing that your balcony, the balcony was made, and after completing the building, the civic authorities at every stage they come and monitor the project, how it is going. The municipal engineers they come and they're planning town planning authorities. They come and just monitor the project. So if there is any violation, they will not give you the OC. So many
Mm.
times this happens. So in such cases, you can file a dispute resolution. You can approach the RERA. Of course, you can go to the civil court also, but then RERA is a right forum.
And also, if
They
you
can
don't
give
get
direct.
the OC, the
Hmm.
authorities, like suppose many, I know of a building which is close by to my place, they don't have the OC, but the case is going on. But the government, the authority, the civic authorities can tell the people to vacate. As ma'am rightly said, that there is some default or some fault in the building, therefore they are not giving the OC. So the person residing over there can be asked to vacate by of course, you can get a stay order on that. We can do that, but the authorities can ask the resident to move out from there because it is not safe. OC is not obtained. Okay.
Hmm.
Yeah. I'll
Yeah,
go to the
because
next slide.
diligence is very important on the part of the flat purchasers or existing flat owners or the new purchasers, whatever. You have
Hmm.
to verify the plan with the civic authority. Normally, supposing the plan is approved for a five-storied building, and the developer constructs a six-storied or seven-storied building, then the building may be termed as unauthorized. So if the
Hmm.
top two stories are unauthorized, the entire building becomes unauthorized. So before you move in, you have to verify these things with the civic authority. So it is better you scrutinize the plan properly and you cross check with the municipal authorities before you purchase a new flat, or even if you move into the existing new accommodation. And
Okay. And
society
also,
formation
yeah.
may take a little longer. As I said, either there are existing flat owners are given the accommodation, but then the newcomers have to be accommodated. The entire building has to be occupied, and thereafter only the society formation will happen.
Hmm.
But the earlier society as a group, you can always, as a group, you can approach the RERA, you can approach the court, anything can happen. But then, otherwise, as a society, you don't have. Only that agreement is the only your sort of a legal document on which you can. Uh,
And also, suppose if you're entering into a redevelopment agreement, okay, now suppose if I have entered into a redevelopment agreement, and so if anything happens to me during the process, if I pass away, then the legal descendants will have to go for a succession
Letter
certificate,
of
for
administration.
a letter of administration. So I have signed the agreement, but unfortunately, due to my early demise or whatever, then my legal heir, will have to go for a letter of administration in the High Court or the concerned jurisdiction. Okay, so that also you need to understand. And what happens is, what would I also recommend is when you enter, as ma'am very rightly said, understanding the entire plan and attending all your AGMs, okay, for a day, like, your society AGMs, attending it and, being attentive to it, seeing all your documents. In fact, many of ma'am and I have got many documents to, as ma'am said, vetting, just vet the documents and see whether everything is in place. Okay, whether it's an interest, it should be a win, as ma'am used the word, win-win situation for all the three parties. It should be a win-win situation. So that vetting also is very important. If you really are into redevelopment, your house is into redevelopment, you can always do that vetting. Yeah. Anything else, ma'am, Chandraman?
No, I think we have covered almost all the things.
Hmm.
Well, so we give it to the audience now. Throw it into the
Yeah.
audience.
Okay.